Hey guys, did your lawsuit get dismissed by the magistrate judge for some stupid reason that didn't make sense? Did you know that the magistrate judge has no jurisdiction to interfere in your case without consent from all parties? Hey guys, did your lawsuit get dismissed by the magistrate judge for some stupid reason that didn't make sense? Did you know the magistrate judge has no jurisdiction to interfere in your case without consent from all parties? If you're tired of the court violating your rights, now you have an affordable option you can use to hold the magistrate judge liable for not following the laws or the court's rules they took an oath to uphold. This video will review how the magistrate judge dismisses lawsuits without judicial authority. In this video, I will show you what you need to do about this problem and where to get the tools you need to get the job done. I'm a paralegal who teaches people how to defend their property using non-conventional strategies. The attorneys structured the current legal process, and it was not structured to be fair for people. So we must learn how to use non-conventional foreclosure defense strategies to hold the attorneys liable. This video will be part of a playlist entitled Tips and Strategies to Use in Court. Now, I want you guys to understand that these tips and strategies that we're going to be sharing with you can be used in any situation. It doesn't have to be a foreclosure. If you're in court with a lawsuit and the magistrate judge is throwing you out, you need to follow up on this and see what's going on. The court has been dismissing people's lawsuits based on a report from the magistrate judge. When the magistrate judge does not have jurisdiction to be involved in the case. This video will review how you are being violated by the court and what you need to do about it. If this is your first time here and you want to learn how to hold a magistrate judge accountable for dismissing your lawsuit, subscribe down below and click the bell so you don't miss anything, because we are about to get rolling. The magistrate judge has no jurisdiction to be involved in your case without consent from all parties. And you can Google magistrate judge consent form in your state, and most likely you'll pull up the form off of the court website that has all of the information in that you need to know. This is one way the court unlawfully dismisses your case based on an administrative report. The magistrate judge prepares a report of his recommendations about what should happen with your case and sends it to the district judge. The district judge dismisses the case based on the magistrate judge's report and not any rule of law. What we're doing is, when the judge throws your case out, we are moving the judge for reconsideration. And we add a file stamp copy of your lawsuit or the document in dispute with the judge's motion for reconsideration. What we have been doing is moving the judge for reconsideration, and we add a file stamp copy of your lawsuit or the document in dispute to the motion for reconsideration. In the motion for reconsideration, you will outline your argument, the dispute, and attach a file stamp copy of the document or any other exhibits to the motion for reconsideration. This forces the district judge to respond to your pleading on the record. And if the judge still denies your motion, now you have on the record what you need for your appeal. Remember, in the beginning, I mentioned to you the current legal program was structured by attorneys. And the way it's structured, by the time the court gets around to throwing you out, you don't have anything on the record to appeal. And that's why we use the non-conventional strategy. You must remember, your goal is not to hurry and get before the judge so the judge can be fair and rule in your favor, because that's never going to happen. The judge is never going to help you win. And that's my opinion. Your goal should be to stay in the ring, stay in court, and get facts on the record that you need for your appeal. As soon as a judge violates the law or court rules to give the other party an unfair advantage, you need to address it and hold the party blocking you from getting your day in court liable. My suggestion is to the motion for reconsideration, outline your argument in the motion, and attach your file stamp exhibits of the lawsuit or whatever it is that's a problem, so that all of that is right before the judge and on the record for the appellate court to review. I would have the notice of claim against the magistrate judge and the motion to recuse the judge ready, because you will have to get everything done within the 10-day window time frame you have to object to the judge's order. I would also have your notice of appeal ready. The notice of appeal is like a page and a half or 2 pages long. It's not that big a deal. You just write on my notice of appeal and your case number and everything, and then you just stick it right in the court. I've included that document in the package. After you file the motion for reconsideration, I would wait a day or so to see if they're going to reconsider and let you enter into court. Basically, you're going to wait and see if they're going to let you pass the first obstacle that they throw in front of you. Now, after I file the motion for reconsideration, I would wait a day or so to see if they're going to reconsider and let you in court, or if they're going to continue ugly. If they continue ugly, you can file the objection and notice of claim and the motion to recuse. And the following day, I would file the notice of appeal before the judge can respond. And the reason why you do that, because once you file the notice of appeal, the lower court has no jurisdiction and everything has to be sent over to the other court. So this way you'll be able to get a couple of licks in without the judge responding to it. And you'll be able to show in the appellate court a little more dirt. Once you file a notice of appeal, the lower court does not have jurisdiction, and the appeals court can see what them fools been up to. Now, I'm going to review the documents and show you what the front page looks like of the document that you're going to be using against the magistrate judge. And I will also share information that you need to know about the document and the strategy behind using it. So let me open the share window so we can take a look at these documents. Okay, here we go. When you complete the checkout process, this zip file will be sent to your, this zip file here will be sent, it'll actually look like this, will be sent to your email that's connected to your credit card or your PayPal account or whatever. So you'll have to go look for it. If you don't find it, you might want to check your spam. And when you click on it, it opens up to these documents. So the first document is the objection and notice of claim. Now here you have some instructions. You want to replace the red font with your information and turn all the red font to black. The instructions that's in red font, you need to delete when you completed the personalization of the document. And you can see your name goes here, you'd be John Doe, the court heading, your name here, and this is what you're going to file against the judge. Now, it's important to remember, this document is set up as a notice of claim for people who have time and can, challenge them. If you don't have time and you need to go ahead and file this claim against the judge because you're about to be evicted or whatever, just remove the notice of out of the title, and it may be in the document in 1 or 2 places, and this is your claim. This is your lawsuit. And that's the way I roll. We want them to know what you're bringing to the table when you serve them the notice so they can see what's going on. Our goal is not to have to go to court. We want them to throw in the towel. So you can see this is structured very strongly. Now, the Administrative Procedures Act of 1946 is actually a federal law that was enacted in 1946. And if you research this, you have to look up the Administrative Procedures Act of 1946. If you don't put of 1946 on it, you will end up pulling up Cornell Law Library of BS, of misleading information that the attorneys have on there. Now, this law, this Administrative Procedures Act of 1946 mandates that all corporations must have their policies and procedures in line with the Constitution. And this is an administrative issue, so you can't sue for money for this, but what you can do is you force them you force the corporation to change their policies and procedures. And they don't like this. This is a big deal for them. All of their procedures and policies are not in line with the Constitution. So this is a big deal for them. And we added that right here to, to hopefully help them change their mind about throwing you out the door and at least let you pass the first hurdle. Obstruction of the administration of justice. Now, in criminal, you would say the court violated your right to due process. Okay, that's in criminal. A lot of people say that in civil, but that's not the way you say it in civil. If you're being stomped on in civil, you refer to it as obstruction of the administration of justice. And that's how you should always refer to you being violated in court, because it lets the court, the officer of the court, know that you have a little more education than most people and that you're serious. And violation of the Constitution under the color of law, whole thing. We're going to go ahead and move over to the next one. Now, this document is your notice of recusal of a magistrate judge pursuant to 28 U.S.C. section 455. And I would advise that you study this document very well. And you actually both of them, because you guys need to know them. And you can see in this document, it says all the judge has to do is have the appearance of impartiality, and that's a problem. And your argument is simple. The judge is not following the rules. In a lot of people's cases, the judge is allowing the attorneys to escape the court rule that says no corporation can go into court pro se. The judge is allowing the attorneys to represent the law firm and the attorney that's named in the lawsuit, and that's a no-no. And in that demand to strike the attorney's notice of appearance, it outlines the whole thing. And if the judge is going to allow this, this is what I would want to appeal, because this is something that you can stick right in the judge's face and show that the judge is violating the laws, and he's also violating the court rules. And in doing so, he's giving the attorneys unfair advantage over you. And that's why you want to go after him. People need to understand, when you're fighting in court, it's not going to be a cakewalk, okay? You can take the best documents right in there and stick them right in their face, and the judge is it's not going to be a cakewalk. What you're going to have to do is you're going to have to attack whoever it is that's blocking you from getting in court. And at the end of the day, it really doesn't matter if you sue the judge or the court or the attorneys or the clerk. Whoever's blocking you from getting in court, that's who we need to add to the paperwork and get addressed. Because until you make them treat you fair and follow the same rules they're trying to make you follow, you're not going to have a chance in hell to make them stand down and get out of your face. Now, I've added this notice of appeal in. The notice of appeal, a lot of people get freaked out about it. It's not that big a deal. It's just a 1 or 2 page document saying that, that you're going to be filing your notice of appeal. It puts the court on notice. As you can see here, it's pretty much already laid out. You want to put the court, the case number, the court heading over here, or you could put the court heading at the top. Pretty simple. Okay, so let's move on to the next one. Now, I've included a magistrate judge consent form from the state of Texas, and I want to review that with you guys. I've included it in there so you can see what it looks like. If you Google magistrate judge consent form in your state, you probably could pull it up. That's how I found this one. I just put a magistrate judge consent form and put it in Texas and pulled it up. You may have to go to the federal court website and look up the forms to find it. But you can see here, it outlines everything that the magistrate judge is supposed to do. And on the second page here is the consent part, and it has it states the law right here, showing that you have to voluntarily consent for the judge to have jurisdiction. And sometimes they send you this paperwork, and most people don't send it back. But the way they roll is like this. If you don't object, then they assume that you are in agreement through acquiescence. So when you file your lawsuit, you could ask for this form if you want to. And what I usually tell people to do is write in black marker, I do not consent for the magistrate judge to be involved in my case. And then I just put my signature on it. I don't sign it, I just put my signature on it. And ask and tell them to make sure that the judge sees it, because I don't know why anybody would want a lesser judge involved in their case. The magistrate judge is just supposed to be doing other stuff. He's not supposed to be making judicial determinations and doing all this stuff without your consent. And a lot of times what they do is if they do ask you for your consent, they'll tell you in a manner to make it look like the district judge is really busy and you can use the magistrate judge and kind of move things along faster. Well, here's the deal, newsflash. Attorneys are full of crap, and anytime you're moving things faster through the court, it's not helping you. And I've also included some notes here that I used when I was putting this package together, so you can have a little more information about it. I included that in the packet. So in this packet, we only have a few documents. Now, if you have invested in my program and you are facing this situation and need this packet, you need to contact me on our foreclosure rescue or foreclosure help private Facebook page, or send me an email or something, and I'll email it out to you. Send me an email to winincourts1, the number 1, @gmail.com, or just give me a call. I'm going to have this package posted on my website, but it's probably going to take me a day or so before I get it posted. You can give me a call and reach me at 913-240-0227, and I'll leave a link into the package, and I'll also leave my phone number down below and the email address. I will have this new magistrate judge reconsideration package posted on my website in a few days for that low coronavirus sale price of $200. Remember, you only have 10 days to move the court for reconsideration. So you need to be able to get all of this stuff done within that time frame. And remember, you want to file your notice of appeal after you file your notice of claim against the judge and your motion for reconsideration. You want to file a notice of appeal like the next day, and that'll jam up the judge because he won't have time to answer through all this stuff, and you'll snatch the jurisdiction away from them and move it over to the appellate court, so those people over there can see what these fools have been doing over here. And my website is at winincourtnow.com when I do eventually get this uploaded and ready to go. So like I said, if you're in a hurry and you need this, you need to just ring me up. Our next video, we're going to talk about another subject that people need to know when it's time to go to court. And you're going to have to come and check us out to see what that is. Now remember, if you guys want to learn how to keep the judge from throwing you out of court, subscribe down below and click the bell so you don't miss anything.